Hi, I'm Anna Denton-Jones, and in today's session, I want to talk about confidentiality. Now, in terms of confidential information, we've probably got a spectrum of things that we're talking about, from the high end sort of trade secrets and secret formulas and processes that an organisation might use, to the other end of the spectrum where we might be talking about information that somebody carries away in their own head, that's just gleaned from their years of experience, with somewhere in the middle perhaps there being databases and things that people have put together, perhaps from information that is publicly available, but it's taken time and energy and ingenuity to collate all that information in a particular manner. Now, the employer obviously wants to protect as much of that spectrum as is possible, and the situation breaks down into two, really: the situation where somebody is still your employee and the situation where somebody has left. Whilst somebody is your employee, they are bound by an implied duty in the contract of employment, that of fidelity to you as employer. They have a duty of good faith towards you, so they shouldn't be taking information that is yours and using it for their own purpose, perhaps to take preparatory steps to set up in competition with you, or to divert work perhaps to themselves in their own spare time, or copying that information for use after they've left. If you did catch somebody doing that or breaching that confidentiality, so I'll just give you the example of somebody who works in IT coming across email information, perhaps circulating details of staff salaries that you would regard as confidential, you would then be entitled to take action against them, perhaps for a breach of trust and a breach of that duty of fidelity. You're more likely to be able to take action if you have spelt out to the employees what you regard as confidential. So actually, relying on the implied duty of fidelity perhaps isn't enough. We need to go further and have an express term in the contract of employment. The advantage of that express term is it gives you an opportunity to just set out what is regarded as confidential information within an organisation. So I quite often see clauses that aren't very well written, that just kind of say something along the lines that, confidential information is whatever we regard as confidential information, which doesn't really tell the employees what sorts of things need to be protected. You can enhance your ability to protect that information by taking practical steps to make sure that that information is not circulated widely. So it's circulating things perhaps only on a need-to-know basis. It might be password protecting and encrypting things if it's electronic. It might be marking documents as confidential, emails as confidential. It might be, cracking down on email traffic to personal email addresses to stop people from sending themselves things home that you wouldn't want to go outside of the organisation. It might be banning memory sticks so people can't download bits and pieces in that way. There are lots of practical steps that employers can take, and it might be worth you having a think about what steps you're taking in your organisation. Once somebody has left your organisation, the implied term of fidelity obviously is gone, so you're reliant then upon whatever you have put in the contract as regards post-termination restrictions. So it's very, very important to have restrictive covenants and to have an express confidentiality clause in order to protect confidential information. I sometimes hear, perhaps on forums where I read, that people are saying within the HR community, don't bother having restrictive covenants, you can never enforce them. They're not worth the paper they're written on, comments like that. That's absolutely not the case. Restrictive covenants have a really high value. I see it all the time with individuals who are absolutely petrified that their employer is going to take some kind of enforcement action against them in respect to the activities that they've been involved in. So they then adjust their behaviour accordingly. So there's a massive deterrent effect from restrictive covenants. Also, if they are well drafted, they're highly likely to be enforceable. Obviously, you need to draft those in a particular way to make sure that they are only protecting your legitimate interests and aren't written too broadly, but that's certainly something that we can help you with. If you need to ask me any questions about today's session, please do give me an email. It's adenton@refreshinglawltd.co.uk. Thank you.